Well, my first sentence is a response to Oona's challenge about the use of customary international law to make the U.S. Do something that it otherwise did not want to do. And I think as long as the U.S. includes U.S. nationals, then I would certainly cite all of the Alien Tort Statute litigation since Florida. My second sentence, which does have a question mark at the end, is for Laura, mainly since she mentioned Medellin, but and since Oona almost completely avoided the discussion of customary international law, I still would like to hear her comments on it, is that how can customary international law be self-executing if an agreement negotiated by the executive branch and passed by the Senate through the treaty-making process provided for in the Constitution not be self-executing without a specific additional congressional action?
I'll take the first, if that's okay, on this Alien Tort Claims Act question or Alien Tort Statute. So I think that actually, again, makes my point, because why are we talking about customary international law there? Because the Alien Tort Statute says that aliens may sue for civil damages for violation of, quote, the law of nations. So it's a statute that we're talking about that refers us to, quote, the law of nations, which the court has interpreted to mean customary international law. So the Supreme Court was interpreting a statute there, right? And so it's a statute that you're looking to. If you could get rid of the whole line of cases, the whole entire Alien Tort Claims Act set of cases by getting rid of the Alien Tort Claims Act or Alien Tort Statute. It's referred to as both of those, right? Well, I'm not advocating that, but I'm saying the key point is it's not customary international law that's doing the work there. It's a statute that's doing the work. And the customary international law is only coming in through the statute. So again, I don't think that's making the case that customary international law is having a direct effect. And in fact, just to answer your more general question, I can't think of an example, again, and I still haven't yet heard one, where customary international law is requiring the U.S. to act in a way that it is forcing U.S. to act in a way that it otherwise wouldn't have chosen to do. Again, the Alien Tort Claims Act doesn't do it.
Laura, do you want?
I can't really add to that because it's true. Congress can, and if we talk about sovereignty, Congress can choose to restrict the court's jurisdiction on whether it would hear any new common law crimes, although also in that case of the recent one of Sosa, that it did itself say, the court said that we have this jurisdiction, but we're going to interpret this extremely narrowly. And the case before us does not, arbitrary detention is not one of those examples where there is a common law crime that we should now introduce.
Look, what my fellow panelists are saying is we can always defy international law. Yeah, it's true, we can defy treaties. As a matter of fact, Southern governors could defy federal law. And then it's a question, will we send in troops? I thought the question was, is law being made for us by other people? And these examples are precisely laws being made for us by other people. There are all these customary norms in which we're being told, well, this is not a customary norm. It doesn't matter whether you agreed, everyone else agreed, so that's good enough. Excuse me, that's not good enough.
Can you give me an example of where that's happened?
I believe in a lot of the disputes about law of war issues, people have been citing treaties that we are not parties to. And they say, starting with the International Committee of the Red Cross, well, everyone else has agreed to it, so it's like as if you agreed to it anyway, it's custom. And I'm sorry, that's not good enough.
99.9% of the arguments, well, maybe I should leave this to Laura, but I've been looking at this pretty closely, and as far as I can tell, almost every argument that's made in that context are with regard to Geneva Conventions that we, in fact, have ratified.
No, a lot is based on, I'm sorry, please.
Yeah, I can't believe I'm going to be helping you with this. I think you offered me an invitation earlier to also take a bite with your mentioned ICRC in your opening remarks, and then I hesitate because I realize they don't pay me anymore. But nevertheless, that's why I'm here, I think.
Go right ahead and bite.
On the customary law issue, I mean, it's the ICRC, I'm surprised no one raised or brought it up, or with the last question that was asked, I'm surprised it wasn't brought up. The ICRC actually produced a 3-volume set of its understanding of what is customary international humanitarian law. Now, that was done at the behest of states, just to let you know and to be fair, because there are these international conferences that bring together all parties of the Geneva Conventions, which is every country in the world, as well as the national societies from around the world, and they pass, obviously non-binding things, but by consensus, they thought, oh, it would be kind of good to know, to have some research done into what are some of these customary rules that apply during armed conflict. So that's what started it, and the ICRC did that. And the US has taken issue with certain methodologies of how ICRC has done the studies with some of the rules, which it is fair to do. This is not a binding document. This is just a reflection of trying to look at state practice and opinio juris and coming up with a perspective of what the customary rules are. It's obviously inappropriate to tell a state that's not party to a treaty that it's bound by its rules if there's not some basis in customary international law. It was asked earlier, well, how do we handle these different interpretations? It's sort of the bottom line then, if treaties have different interpretations, that they aren't worth anything. And I think we've tried to make the case that there are some practical needs for treaties. But even in the law of war treaties, that, you know, some of those date back to the late 1800s, my role as legal advisor, since there aren't formal mechanisms with international humanitarian law, well, there are some courts, but not on some of the day-to-day interpretations, is to discuss with the state authorities. And it was a healthy give and take. This is our understanding of what the law means, and that's your understanding of the law means. And you don't do it because you don't, out of a legal obligation, but you're going to do this and this action because of a policy decision. Great. That still may lead to the same outcome, at least for an organization like the International Committee of the Red Cross. On your comments earlier in your opening statement, I wasn't sure if your concern was of an organization like ICRC being involved and being out there, or that the U.S. would actually care to want to bother to cite that it's doing things in cooperation with the ICRC.
It's a private organization. It has no more authority than the Federalist Society. I think it has less authority than the Federalist Society when it comes to American law, because the Federalist Society is at least an American organization.
So the concern is really that the United States government thinks it's worthwhile to cite to the ICRC, and we should not, or to say that it's working with the ICRC.
I think they are treating it as if it is quasi-authoritative, which is, of course, a role that the ICRC is only too happy to play. It's not exactly in charge, but it's sort of counselor to humanity. Right. And there's no such category as that.
But I mean, I think it's interesting because I think there are, you know, I think the U.S. does want to cite sometimes that it's in working with the ICRC because the values it espouses that we are in compliance with our treaties, that we do not do certain behavior, we do engage in other certain behavior.
Weak-minded politicians do many unfortunate things, right? And they try to bolster their position however they can with whatever is at hand, and they give away sovereign powers, as in Europe, or they sign treaties which they shouldn't, or they enact statutes which they shouldn't. But at the end of the day, you cannot say, well, this is no infringement on sovereignty because somebody agreed to it. I mean, there are certain limits of what we could agree to, and I do not think it can be constitutional to have a statute which says whatever the Secretary General of the UN says, that will be binding on us. It could be enacted by Congress. That's not a legitimate statute. And similarly, it's not a legitimate way to make customary law to say some people in Switzerland did a study and now that is customary international law. That's ridiculous.
All right. We are over time. There have been two gentlemen who have been waiting very patiently there, so I'd ask you to keep your questions very sharp and our responses brief, and then we can stay more or less on schedule. Sir.
A very short question on a topic that I think we're all very concerned about, and that is the increasing attempts of foreign governments or NGOs to hold or attempt to accuse or hold accountable our troops in war or our politicians for war crimes. The question I have for the panel is this really happening? How big of a problem is it? Is there anything we can do to stop it?
Yeah.
I mean, I think there are two different questions there. If it's states holding U.S. troops accountable, we could talk, we don't have time here, but the whole issue of the International Criminal Court and universal jurisdiction that occurs under certain law of war treaties. But also with the idea of NGOs holding individuals that can't really hold anybody accountable per se. And I don't mean to stand up here and say that everything that NGOs do is great, but isn't that what also is important in a democracy where there's rule of law, that NGOs and civil society has actually a greater say and then can bring about change? I know one of the criticisms in general for international human rights treaties, and Professor Hathaway's written on this, so I should really turn to her, is that, you know, there's no great costs for dictatorships to sign on to these treaties. It makes them look good in the international community. And then at home, there aren't these mechanisms that really ensure that the government itself will live up to its obligations. But here in a democracy, we have civil society that does speak out and NGOs. And so I think we need to balance, yes, what the roles are, and they should be in perspective, but I think there is a key role here for the